everybody exit, be a little quieter.
Yeah, I understand, Your Honor. If it would pleasure the bench, my name is Christopher Allen Colon, family of Hauser. I am a sovereign. I am a son of the Most High. A sovereign according to the Tennessee Constitution, Article 1, Section 31.
One question first. Did you want to reserve any time for rebuttal?
I don't believe I'm going to need to rebut. I think by the end of this argument that I have, there won't be a need for it personally. I am the beneficiary et al., appearing specially in propria persona, not pro se. I'm Shuri Juris and the beneficiary of the Social Security Sesticate Trust, the all caps name Christopher Allen Hauser.
Are you the defendant, Christopher Allen Hauser?
I would be Christopher Allen, the beneficiary of the all caps name.
So that's a no or a yes?
I would be, you would consider me, the state would consider me as the defendant.
Okay.
Okay?
Go ahead.
To answer your question, there's one question I do have. Does this court recognize and adhere to the decisions made by SCOTUS? It does? I assume you're acquiescing, so. If so, the United States Supreme Court declared in 1969 the ability to place a lien upon a man's property, such as to temporarily deprive him of its beneficial use without any judicial determination of probable cause, dates back to medieval England, but also to Roman times, unquote. That's Snydash versus Family Finance Corporation. According to this decision, there is no need for legal basis per Tennessee Code annotated 39-17-117, A1, where it states, when such person has no reasonable basis or any legal cause, unquote. But we did, however, go the extra mile to create the reasonable basis and legal cause, evidenced by common law contract created via the postal rule. This contract is referred to as the conditional acceptance. You'll find that as Exhibit A for ID only in the case. That's the contract. The next point I'd like to get to is the withholding of exculpatory evidence. We did, in fact, have a valid contract with the legal victims by the states interjecting themselves in the middle of the contract. This would be considered interfering with the obligations of contract, which would make this a Brady violation, Brady versus Maryland. Along with the controlling case for Tennessee is Tommy Newley versus State of Tennessee, Supreme Court at Jackson. In the transcripts, they start at page, the court transcripts, the hearing transcripts. They start at page 603, line 12. The jury exits the courtroom. Then there's a conversation between the alleged defense attorneys and the prosecution for the state and Cheryl Blackburn, the judge of Division III. If you read that, 603 through 605, you'll see that they discussed removing the contract from out of the sight of the jury. This is considered withholding exculpatory evidence. There was two things that they marked for ID only, Exhibit A and Exhibit B. Exhibit A is the contract. Exhibit B is the affidavits that the public officials filed, removing the UCC ones off of out of the state's record. This law came about because of what we did in the winter of 2017.
And did you have a security agreement with these public
Yes,
officials?
we did.
And they signed it?
They signed it. If you understand the postal rule, when you send something certified mail, return receipt, the little green card comes back, that is the signature card.
Well, I understand a contract requires a meeting of the mind. Did you have a meeting of a mind that this was a security agreement?
Yes, it was. And the security agreement, the state continued to call it a lien. And the UCC one, if you guys remember, if y'all remember the case, you heard it. If you go back on your YouTube channel, there were 10,000 views on that hearing, 40,000 on the Supreme Court case. I'm viral YouTube, content creator. So they signed those sworn affidavits saying that they had no contract, but in the affidavit they speak about the contract. They did that in the summer, roughly, in the summer of 2017. Then they came back in 2018 and testified they had no contract. But they read the UCC 1 filings that said, under common law contract number, blah, blah, blah. Every one of them, every one of the witnesses, they either said they had no contract or they got something in the mail, which is the contract. According to the postal rule, when you send me a summons to court, you send it certified mail. I agree that I'm going to be there when I sign that. That's why they send stuff certified mail. That's you creating a contract with whatever court is bringing you in that you agree to show up. If you don't show up, they rule in favor of whatever. In this whole situation that we have, they withhold this. They signed sworn affidavits, and then they turned around and committed aggravated perjury, every one, including my ex-wife. I'll get into that. So that's our argument on withholding exculpatory evidence. That's evidence, I'm sure you all know, that's evidence that may or may not have vindicated us.
Did you raise that on direct appeal?
No, I didn't raise anything on direct appeal, and I'll answer that question just briefly. The other issue is severance. We filed post-conviction. I filed post-conviction on behalf of myself et al., the rest of the guys that's in the group. I sent them, I mailed them out via the postal rule from Newport, Tennessee on the 9th of May. I sent one copy to Jonathan Skermetti. He got his on the 13th of May. I sent one to Cheryl Blackburn. She got hers on the 15th of May. The one that went to Joseph Day was, this is, and it should be in the record, this is the signature card that he signed. If you'll notice up here in the corner, the date's been changed to 5/16. I've got friends, I'm a veteran, I write claims, help veterans get benefits in East Tennessee for the Department of Veterans, the DAV. I've showed it to guys that are retired military, retired postal worker. Hey, what do you think of this? Oh, well, they've altered the date. That's where we were refused post-conviction relief at. When the severance, they lack jurisdiction The motion to sever during pretrial and throughout the trial were denied, according to Tennessee Rule, a criminal procedure, Rule 14. Severance is part of pretrial procedure. The trial court denied all motions for severance during the pretrial procedure for convenience purposes. Furthermore, according to Rule 14, there must be a request from one of the defendants for the trial court to even consider severance, severing one defendant from the other. If there was a show of the motion submitted by Lee Cromwell requesting severance because Cheryl Blackburn sent a notice to this court that she wasn't going to look at ours because we were 1 day late. And in that document, she admits that she's 9 months late, reviewing it, and that we didn't file in a timely manner, but Lee Cromwell did. Even if this shenanigans in the Postal Service, and there is an ongoing investigation with the United States Postal Service Office of Inspector General on this matter. I haven't heard the results of it yet, but this isn't right, what happened. We should, even if it wasn't, say it was a month late, it still should have been considered as an amendment to Lee Cromwell's, because we can't be severed. You can't sever after the conviction, according to Rule 14.
Remind me again who Lee Cromwell is.
Lee Cromwell he was involved, during this time, he was involved in a vehicular homicide in East Tennessee. The accelerator pedal was frayed on the truck. He put it in reverse, ran over somebody, and killed him. He did what we did. All we did was mail contracts to people that they acquiesced to because they didn't rebut the contract. That's where this comes in at. Now, we didn't file any liens. We took the UCC-1 filings and we sent them to the United States Treasury. The United States Treasury filed the liens. They used the IRS to collect the money. The IRS hit me with a frivolous filing twice. I beat it in court. I beat the IRS in court. And that was based on my ex-wife's bankruptcy. Tennessee said we had no legal basis to do what we did. The federal government agrees with us. The IRS, the tax court, and the Treasury all agree that we had genuine filings. The federal court in Greenville, my ex-wife came and testified against me. She said she had no debt with me. And then she did that at the trial in April of 18. By December of 18, she was filing the $4 million debt in bankruptcy. Okay? And by doing that, Title 11, United States Code, Section 532, subsection A2, says, of the section where bar discharge only where bankrupt has actual knowledge of falsity of the statement or reckless disregard for the truth. She testified that she had no debt with me, took it to bankruptcy, scheduled it, the federal court discharged it. Only provable debts can be discharged in bankruptcy. You cannot take a fraudulent debt into bankruptcy and have it discharged. The judgment, I'm going to move on to the judgment orders. Judgment orders, I'm sure you're all familiar with. Judgment orders happen after the judge does the sentencing. And in the Tennessee Constitution, per Article 6, Section 12, it says all writs and other processes shall run in the name of the state of Tennessee and bear test and be signed by the respective clerks. There's allegedly, well, I've seen them now, but there's 42 judgment sheets that haven't been filed. Those judgment sheets is when your time starts. This is when your time starts. The date on this is when you was tried. The Constitution says that they have to be stamped, filed, and signed by the clerk. If you look at the indictment was initialed by someone named KT. It's not signed. Okay? None of the judgment orders were stamped and filed per Rule 60.02 and the Tennessee Constitution, Article 6, Section 12. Since the judgment orders cannot be corrected per rule, the judgment orders are void. See also Rule 12, B-E, or Bravo Echo, and Rule B-2 of the Tennessee Rules of Criminal Procedure. For that matter, the indictment from the grand juries were not signed respectively by the clerks. At the jury trial, I already explained this. According to that, that's Birmingham Title 11 United States Code, Section 533, subsection A2. That's Birmingham Trust National Bank versus Case. Title 11 United States Code, see Section 532, Note 341, Paragraph 15. A bankrupt is just discharged from provable debt if they are scheduled, properly scheduled. Okay? My ex-wife testified in court that she had no debt with me. That's in the transcripts. Turned around 9 months later and scheduled this in bankruptcy. Why didn't she do like the public officials did? Go to the state secretary because of the new law that was created because of what we did that year and have him removed. Because it's for public officials, right? The lien, we didn't, like I said, we didn't lien anybody. And there's 3 federal agencies agreeing that our liens are valid. What I did is I sent it, what we did, was send a contract to the Treasury. The Secretary of the Treasury at the time was Jacob Lew. Here's $204 million in lien securities. These are yours. If you can collect them, you get 35%. You don't think the Treasury is going to want 35% of $200 million? And we had a combined amount of almost $2 billion in lien securities. The federal government has agreed with what we did. In closing, we were picked up on February the 17th, or February the 15th of 2017. I was told there was a warrant. I asked for the warrant. Oh, we'll show it to you when we question you. Never seen a warrant. Took me down, read me the rights, took us all to Nashville, where they said there was an indictment. I've never seen an indictment until I was released and went to Emma Tennett's office and seen the actual case. 2 weeks later, they had us in Blackburn's court, where I challenged a jurisdiction. We all did. You can't proceed until you answer the challenge. She said, these are some serious charges. How do you plead? I said, I don't. Why? Murder is a serious charge. Rape is a serious charge. Child molestation is a serious charge. And you do not want to go to prison for that. So where's the nature and cause? How do you plead? I don't. Well, I'm going to plead for you. You know you can't practice law from the bench. If she's a judge making a plea for me, she's saying she's my counsel, which we never seen. The whole 15 months I was locked up in Davidson County Jail, I never talked to an attorney. Never gave any attorney any power of attorney. They had a trial that lasted 5 days. The judge said, you can come in, but you'll not be allowed to say anything. Where's the Sixth Amendment in that? To this day, Tennessee has yet to put a single piece of paper in my hand saying they had the right to do anything that they did. And they interfered with the obligation of our contract.
Before your time runs out, this is a post-conviction relief petition, and almost everything I've heard has to do with a direct appeal. What post-conviction relief are you seeking, and what are you claiming entitles you to post-conviction relief?
We deserve post-conviction relief. Blackburn's gone. She's retired. We deserve to finally be heard. We've never been heard. If you take someone and you hold them using unlawful force, that's kidnapping. I was sexually assaulted by a guard in Davidson County, and I reported it, and no cop ever came and took my testimony.
All right.
You understand where this is at? We deserve to be heard. We, the people, Article 1, Section 1, have the right to abolish, reform, alter, or abolish the government in any manner we think proper. That's why I say I'm not here pro se.
All right. Thank you, Mr. Hauser.
Thank you very much, and I hope you consider. Like I said, I'm only doing this because you guys have never heard that our due process was violated. Never heard it. Now you have, and now we can go to the federal courts and do a 1983. Thank you very much for y'all's day.
Right. General?
Good morning, Your Honors. May it please the court. Liz Evan on behalf of the state. The only issue that's properly before the court today is whether this petition was timely, and it was not. There is no tolling provision that applies statutorily, and as far as due process tolling, it has to be some kind of event that's beyond the petitioner's control. And notably here, Davidson County Criminal Court Local Rule 6 allows for e-filing. He could have walked it over and handed it in the proper time. None of these things were done, and so therefore it simply was untimely, which is a strict jurisdictional bar. And Judge Holloway, you're correct that the vast majority of the allegations in the petition could have or were raised on direct appeal, so they're not even colorable. Potentially he might have an ineffective assistance claim, if he were appointed counsel and that was fleshed out, but that only comes if the petition itself is timely filed, and this was not. I'm not going to belabor the point because I know it's been a long morning, but I'm happy to entertain questions from the panel. We would ask that you affirm.
All right. Thank you, General. All right. That completes the morning docket. We'll be in recess till 1:30.
All rise.
Y'all follow YouTube and watch the video. There's 10,000 on the first one.